Welcome to Raising the Bar with RebuttalPR, the podcast where we elevate the stories of the plaintiff's bar and dive into the key trends shaping the civil justice system today. I'm your host, Ray DeLorenzi, and in each episode, we'll bring you insightful interviews with leading attorneys, expert perspectives on current legal events, and in-depth discussions on the issues that matter most. Now let's jump in.
We're very selective in the types of cases that we bring. For us, we want to win. Like, one thing that I'll say about me and Mike is, we're very competitive and in a good way, right? We want to bring our clients the best result possible. And you're going to do that when you have really good cases.
Hey everyone, welcome to a new episode of Raising the Bar with RebuttalPR. I'm your host, Ray DeLorenzi, and today, this is our first episode with two guests, so this is extra exciting, double exciting. I'm with Villegas and Michael Canty of Labaton Keller Sucharow. We haven't really gotten into the securities world, and this is our first time doing it, and I'm really excited to have Carol and Michael with us today. Thanks, guys, for joining the podcast.
Thanks for having us.
To be here.
So, you know what, Carol, I want to start with you. And before, I know you're just off a very big case against Meta, which we're going to talk about later in this episode. But I'm always curious about the people behind the cases and how they get into the law in the first place. For those not familiar with Labaton, it's, the heavy hitter, if not the heaviest hitter in the securities world. How did you become a lawyer and get into this space?
Well, I didn't even know securities fraud litigation existed when I was in law school. I did what a lot of people in law school do. I got a high-paying job out of law school at a big New York City firm. And I discovered pretty quickly, maybe in the first couple of years, that it wasn't for me. I was defending corporations who were accused of doing some pretty bad things. And it was kind of hard for me to live with that. So I did a complete 180. And I went to work for victim services in the Bronx, which couldn't be more opposite what I was doing at King & Spalding. And I love that work. I was helping victims of domestic violence get orders of protection, helping them with divorce proceedings. And that kind of led to a relationship with the DA's office in Staten Island, who were helping me with some domestic violence issues. And I ended up getting a job there. And it was one of the coolest jobs I think anyone could ever have as a lawyer. I loved the work that I did there, just doing trials, representing the people, representing victims. It was really, really rewarding. But I kind of missed a little bit some of the high stakes litigation that I did at King & Spalding. And I came upon Labaton, who does plaintiff's work, and they do plaintiff's work against some of the largest law firms in the world. And they represent some amazing clients. And I was like, wow, this is incredible. This is like a way for me to really help clients, help victims of fraud, get redress from these big companies and do it in a way that a lot of people don't realize, which is a class action. And for a lot of our clients, if it weren't for the class action mechanism, they never would have a way to get back money or to vindicate their privacy rights like we did in the Meta case. So it's kind of like the best of both worlds for me, where I could be doing this high stakes federal litigation, but also do it with like a mission driven purpose.
It feels less common these days. I don't know if you see it this way, to do public service. And then, a lot of folks, it's just they're on that, hamster wheel from, law school to big law, and that's it. What did folks say when you left big law and you're like, I'm going to go, work for a prosecutor? I mean, I think they were like, one, are you crazy? But two, they probably assumed you're just going to go back to big law because that isn't as uncommon a path.
So it's funny that you asked that question, because my parents, who come from very humble beginnings in South America, when I got the big job at King & Spalding, my dad was like, wow, I can't believe how much money you're making. Like, I'm so proud of you. And when I left King & Spalding and told my dad I'm working for victim services and I'm going to the DA's office, he actually cried and he was like sad about it. And I said, no, Dad, you don't understand. This is what I really want to do with my life. And it's not about the money. It's about helping people. And also, I was the only Spanish speaking DA in Staten Island. And they have like a pretty large immigrant population there. And I was actually able to help the community. And the DA of Staten Island actually invited my father for a cup of coffee and told him about my work. And then my dad cried again, but it was because he was really proud of me.
Michael, I am curious as to what brought you to Labaton, but also I know you come from a background in public service also.
Yes, yeah. I graduated law school, and my first job was at the Nassau County District Attorney's Office. When I was in law school, I didn't have any lawyers in my family, kind of similar to Carol's background. It was kind of a new endeavor, and classmates would ask me, "What kind of law are you going into? Are you going to do corporate, or are you going to do litigation, transactions?" And I kind of naively said, "No, I'm going to try cases. I'm going to be in a courtroom." I thought that's what all lawyers did. And
Yeah.
I had I had some professors that said, "Well, you should look into the DA's office." I actually said, "Well, what about that U.S. Attorney's office? I heard that's a really good job. So you can't really go there right out of law school. You should go to a local DA's office." And I grew up in Nassau County on Long Island, and I was thrilled to have the opportunity to work there. I got to work with a lot of great people, and everybody asks about my experience trying cases as a federal prosecutor, but I really learned the trade on how to try cases at the DA's office. You are quite literally thrown into the deep end. You're given 200, 250 misdemeanor cases to handle, just a few months out of law school. And then a year later, you moved into to handling serious violent felonies where you have maybe 40 or 50 cases. And from there, my career progressed. I was an arson prosecutor and then ultimately a homicide prosecutor. And from there, an opportunity presented itself to work at the U.S. Attorney's Office in Brooklyn, the Eastern District of New York. And I immediately jumped at the opportunity. I applied and I was accepted there, and then spent the better part of 6.5 years working on federal cases. And then Labaton was really it was not intended that I was looking to leave public service. A colleague of mine had interviewed at Labaton, and his father was a plaintiff's lawyer. And he said, "I think you'd be really good at this. You should really reach out. They're looking to hire somebody." And I kind of took the interview more out of curiosity, and I was really, really impressed with the people at Labaton and the work they were doing. It was very similar to the work I did as a federal prosecutor. Um, and I always tell people a little bit more difficult in certain respects. I didn't have the full arm of the law backing me up. I didn't have subpoena authority. I didn't have FBI agents or DEA agents. It was a little more difficult in getting witnesses to speak to you as a civil litigant, but the work was equally rewarding. And I thought I'd give it a few years, and now we're on to 8 years since I left, and it's just been a great experience working. So kind of a non-traditional route, but I always tell people I love being a lawyer. I get so disappointed when I hear people tell young people, "Oh, don't go to law school, you'll hate it," or "Don't be a lawyer, it's a terrible profession." I love it. I think it's so rewarding. It has provided me an opportunity to work on great things, work with great people, and really make a difference.
So, I'd be remiss not to ask, based upon your experience in the Eastern District of New York, there's been a bit of turmoil. I don't know if you've, seen the news in the last, 8 months or so, about what's going on in some of those federal districts in New York. I know Southern District, maybe a bit more exciting, for lack of a better term. But I'm just curious, from being there, what is, your take on it? And I know those offices also have prided themselves on their independence.
Yes.
And I'm just curious, in these times, like, what's your take on what's going on in those offices and amongst the federal, district, enforcement offices generally?
Yeah, it's interesting. I look at those in the career prosecutors that are in supervisory positions now, and these were young assistants that I was supervising when I was a deputy chief in general crime. So it feels like it was yesterday that I left, but they have kind of worked their way through the office. I always kind of have taken the policy. I always get a little saddened when people comment from the outside. I'm not in the office, so I can tell you what I know from the colleagues that I speak to, and the ones that I know that are still in the office are the consummate professionals, and they know the job. They know what the task is. They know that their obligation is to try to keep our community and our nation safe. I worked in our national security section primarily when I was in Brooklyn, and they're still doing great work. I know that politics kind of always kind of plays a part, but I will tell you that those that I've spoke to recently, they are they know the task. I think they try not to get distracted by that. They know the work that they have to do and the importance of the work they do. And I always like to see, and when the press releases come out, some of the cases that they're working on, because I know how hard it is to kind of develop some of those cases. So maybe I'm an optimist, but I'm always impressed with the work they're doing. And I'm always loath to comment on some of the work from the outside. I don't think it's fair to those that are on the inside. They may know stuff that we don't know. So I'm just there, kind of an outsider, supporting them and cheering them on because it really is important work.
Yeah, I have friends in those offices, and it's just like a nose to the grindstone kind of mentality. And I think a lot of them have a very great ability to block out the politics, which there's politics regardless of the administration. Maybe it's a bit more potent in certain ones, but no, I agree. It's just like, onward. We have cases to prosecute. So
That's right. Yeah.
yeah. I want to ask you both about having that trial experience and being in the courtroom, in a prosecutor's office or working for domestic violence victims. You may be in the courtroom like, 4 times a week, you're just constantly doing that. And that is not very common these days for, many lawyers. They may see the courtroom twice a year or something, if they even see it. So how did those skills translate going to the securities bar?
Yeah, so I think one of the best things that we have at Labaton is the fact that we do have a lot of prosecutors, former prosecutors, people with trial experience. The thing about cases like bet the company cases, high stakes litigation, civil litigation is 1% of all cases go to trial. There's a reason for that, right? It's because there's a lot on the line. But in order for us to be able to drive cases, drive large settlements or, just take a stand in a case and say, look, we're not going to settle for less than X, you have to have the chops behind that. If a defense firm knows that you're the firm that knows how to prepare a trial case and go to trial, they're going to take that threat seriously, a lot more seriously than, say, a firm that maybe doesn't have the same type of experience. So the way Mike operates, I mean, and not to speak for Mike, but I've seen him in action. It's like from the minute you get the complaint, Mike's prepping for trial. And some of the questions he asks in discovery, the things that we do at summary judgment, it's all sort of working backwards from knowing that we're going to get this case trial ready. And, that is a real threat to the big defense firms because they kind of know that the case is going to be worth a lot more for our clients.
Yeah, and I think that also works in reverse, right? We go up against defense counsel where we know if they have trial experience or they don't, and that also figures into the calculus as to how you litigate a case. But to Carol's point, I'm always trying to train young associates at the firm to be prepared to go to trial. We run a summer program. I've done it a few times that I've been at the firm. It's a trial advocacy program for associates, and what it does is it hones skills, whether it's through deposition taking, through brief writing, that ultimately your objective is to create the ability to have a winning case at trial. And we've done that. And like Carol said, we have buy-in from the firm. We get support from the firm to make sure that we have people prepared. Anecdotally, we had a case where we were not looking to settle early. It was a securities case, and ultimately, defense attorney said, "Oh, well, we'll try the case. We'll try the case." And ultimately, they were relieved. They had to bring in trial counsel because when we said we're going to try the case, we meant it, and we pushed that case right to essentially the courthouse steps, and ultimately it settled, but not before the original counsel for the company was replaced with trial counsel, because it wasn't a threat. It was a promise that if we are not able to settle this for what we think is reasonable for the class, we will try it. And that threat we saw through all the way to the point where new counsel came in, and ultimately we were able to get a real value for the class.
So I'm curious that, the structure at Labaton, when you look at on the defense side, it's not uncommon for them to have a law firm that, works up the case, when they're from the time they're served from the complaint, and then they bring in trial counsel. It sounds like you guys, you're taking the case from, drafting the complaint, and you're ready to go, try it yourself, and aren't necessarily looking to bring in a ringer at the last minute, which again, you're seeing that, that's more common in the plaintiff side, but you're also seeing plaintiffs firms do bring in trial counsel as well. Like, what's your sort of structure and your approach to cases? Are you bringing them and going to try them if needed?
Absolutely. I mean, I think there's a real benefit to us in doing that because you have the institutional knowledge from the very beginning of the case. I mean, you live this case, right? Some of these cases go on 4, 5, 6 years. You've been there for every strategic decision. You know the documents. You kind of believe in the case. Like we joke about it a little bit at our firm about drinking the Kool-Aid and like really loving the case and believing in it. That's how we feel about our cases, and I actually think that gives us an edge. You bring trial counsel in at the end, it's like, "Oh, it's a job. I have a trial. I'm gonna do the trial." And I'm sure they're, professionals and they're gonna do a good job, but, like, we have been living this case for 4 to 5 years. It is everything to us, and I think that really makes a difference.
Yeah, and I think you raise a broader issue, which is the plaintiff's bar and Labaton really specifically. We're nimble, so we're able to deploy people that are experts in certain areas. So, for example, if we see somebody is good at brief writing, we will have them focus on brief writing. If we have those that are good at taking depositions, we'll have them work on that. We really try to develop the whole lawyer. And to Carol's point, we identify cases early if we see this as a case that wants to go to trial, and we have the ability to kind of turn on a dime and prepare with people. We don't have people that are specific and stuck in a specific role on a case regardless. If they need to move and pivot to something else where we think that their expertise and their skill set can be deployed, we do that. And I think that's what makes Labaton in particular very successful at what we do.
So I want to talk about the security side, and I know you both lead the part of the practice that does consumer protection and data privacy. Um, and we'll put in the notes of the show. I didn't go in your introduction through all the awards and recognitions you got, and you guys are top, top of the field here. Let's talk about the security side first. And I feel like there's this like misconception out there. I mean, it's really been driven by like, the US Chamber of Commerce that like, company disclosure, stock drops, and then the securities bar is just, doing its thing. And like, that's not how things work. I'm curious, and I'm not looking for you to refute that because we don't need to get into their nonsense. But what I am curious about is from the security side, and we'll talk about the data privacy in a minute. How do you evaluate a case? And what makes it a case that is for, Labaton to say we can make a difference here?
Yeah, I think that when you talk about experience, my experience as a federal prosecutor allowed me to identify fraud. And I think that that's what distinguishes Labaton. One thing that I was particularly concerned about when going to a securities plaintiff's firm was, what kind of firm is it? Is this a firm that is volume, that just files cases, like you said, where there's a stock drop, where there's a disclosure, a stock drop, and then we're going to file a case? Labaton is not like that at all. We have in-house investigators that really dig up information on the case. And what I like, and I always like mentioning this, when we reach out to clients on a new case, so somebody else files a case, our initial reaction is not, "Hey, you should do this case because you have the largest loss." Our first initial reaction is usually, "This case has been filed. We now have 60 days to investigate it. We're going to investigate it. We're going to get back to you." And that, I love that part of the case because that allows us to dig in, to see if the case has some teeth, if the case is a real fraud. And, more often than not, there is fraud, but there are times where we've gone back to clients where we've said, "Look, this is mismanagement," or the disclosures were fairly clear that these risk disclosures, that this was going to happen, and it did happen. Investors were aware. But that's what I really liked about Labaton, is that we have those in-house investigators that give us the ability to really dig in. And I always tell clients, we're not looking for those cases where it's simply a stock drop. Ultimately, like Carol and I talked about, we want cases that are going to have jury appeal, that we're going to be able to convey to a jury, "Hey, look, this is fraud. There were lies here. There were specific statements that were made to investors that they relied on, that insiders knew. Oh, and by the way, they were selling their stock before they disclosed the truth." There's a panoply of information that we look at that create that mosaic of a case where you're like, "Oh, a jury would really like this." So, that's what we do. We're not hesitant to say there's not a case here.
Yeah, I mean, we represent some of the largest state pension funds in the United States. We represent some of the largest asset managers in Europe and around the world. I mean, these are serious clients. They don't want to be embarrassed, and neither do we. We have a reputation to uphold, and it's, both of us having been prosecutors, you feel kind of this like integrity, right, about what you're doing. And there's been a lot of occasions where we've done an investigation and we've said, yeah, no, I wouldn't bring this case. This isn't a real fraud. And I'm really proud of that because we're very selective in the types of cases that we bring. And for us, we want to win. Like one thing that I'll say about me and Mike is, we're very competitive and in a good way, right? We want to bring our clients the best result possible, and you're going to do that when you have really good cases. So, we bring, I don't know, I think it's like every year something like 250 cases get filed, and I think we might look at 40 and we might bring 20. I mean, it's a very small sliver of the market, and that's by design.
And, I brought up the chamber before. I mean, there's been efforts over the years to, in their view, essentially, actually, I'll give like my view, essentially, like deny investors, any legal
Yeah.
recourse, whether forced arbitration, class action bans. There was recently, legislation passed in Delaware that would, change some of the corporate rules, which we won't go down that rabbit hole. But what do you view as the risks to investors from like a regulatory and legislative component, even though we're in an era when people's faith in institutions is, pretty much, the lowest it's ever been.
Yeah, I mean, we didn't get here by accident. I mean, we have to look back, now almost 100 years ago, right? We had the stock market crash. We had total lack of integrity in the markets. We had the creation of the SEC. In reaction to that, we had the passage of the Exchange Act and the Securities Act, right? So Congress saw fit to make those changes. Then we had a period of where maybe there was lack of value for investors, and corporations saw an uptick in what they call strike suits. And what did Congress do? Congress reacted. They passed the PSLRA in 1995, and what that did was, I think for a firm like Labaton, it really was a huge benefit because it created a framework where, look, you have a heightened pleading standard, you have courts requiring those really detailed investigations before you bring a case. So I think we provide tremendous value for investors, and the alternative is hiring 10,000 more SEC prosecutors that really don't have they won't have the bandwidth or the time to do these cases. Some of these cases go 4, 5, 6 years. And we're incentivized to bring cases where we think we're going to be successful. To Carol's point, we're not looking to drag a case out for 4 or 5 years if we think it's going to lose. So I think we provide a real value to the market. And you see that. I mean, you see that without private securities litigation, I think you would see a real change in how corporations disclose information, how they handle insider trading. And from our perspective, now, when you're talking about changes in regulation, and we don't have to get into the politics of it, the private securities litigation provides a real function to investors. And I think that the institutional investors like state pension funds, large institutions are stepping up. I think that sends the message. That's your answer. If these states weren't getting involved, these large public pension funds weren't getting involved, I think, the argument the Chamber of Commerce has would have a little weight. But the fact that you have these states getting involved and leading the charge on these cases really speaks volumes as to how they see the framework. They see it providing real value to their pensioners, to their retirees.
Yeah, the way I like to think about it is all investors want the capital markets to be safe, right? They want companies to be truthfully disclosing things. And throughout, various, presidents and political regimes, like the SEC expands and contracts all the time, right? Some administrations have a lot of regulation around disclosure, some don't have a lot. But one thing that's consistent is we have the courts. And, the law that Mike mentioned, the Private Securities Litigation Reform Act, no matter what's happening with regulation, investors will always be protected because there's always a way for us to go and seek redress for fraud. And companies know that, investors know that. And I think it's just like a really, really important thing that we do.
Yeah, and just to put a finer point on that, we see a lot of executive action, right? Administrations change, executive orders come and go, and you have a new administration change, and all of a sudden the rules change. Not with the PSLRA, right? Because they did it the old-fashioned way, right? They passed it through Congress. Interestingly enough, it was vetoed by President Clinton, and then it was a bipartisan House and Senate overrode the veto to make it a law. So they did it right the way people say they should be doing it, like pass a law. And when you do that, what you have is consistency and you have stability. And I think Carol's right. The markets see the PSLRA as being kind of a backstop to make sure that the markets remain, consistent and have their integrity.
I want to pivot to the data privacy side of your work, which, I don't know if it includes data breach work, but I think when people think data privacy, they think of breach, and that's not necessarily what it means in a lot of instances. And I feel like it requires a different level of sophistication and investigation to figure out the privacy aspect because, and also, and I'm packing in a bunch of questions here. People don't realize their personal data is out there, but I also wonder if people are like just shrug their shoulders, at this point because they're like, it is everywhere. So I'm curious as we talked about your approach to securities work, your approach to data privacy, and how you investigate these cases and figure out what is there when we are just surrounded by so much data and, sort of an environment where it's just, bought and sold on an open market.
It's a great question. And, to answer the first part of your question, I think you're right. It's sort of a different level of sophistication and investigation that we need to be able to do. And essentially, to talk a little bit about the Flow Health case with Meta, it's being able to understand essentially how the technology works and that this code, that Meta developed and gave away to app developers for free was able to essentially record all the data that any user would put into the app and then pull it into its systems and use it in its machine learning algorithms for advertising, right? So there's a lot there to unpack, but there's a lot of investigation that we needed to do to get to that point and sort of figure it out. But it's different than a data breach. And I also think it's different than, and, Mike and I talk about this all the time, like, we're not suing a clothing company because they found out Carol wanted to buy a black jacket and then they served her a bunch of ads on Google. That's not the types of cases we bring, and that's not what this data privacy case is about or the ones we're interested in. I mean, the cases that we bring and the ones we're interested in are ones that involve very intimate private data, the type of data that you don't want anyone to have, like health data, like reproductive health data, like financial data. And I think that there's a difference, right? Like a lot of people are like, oh, yeah, whatever. They all have my information. But do you really think that Meta has information about when you're ovulating? Probably not. And I think that this case kind of shed a spotlight on some of the data that companies like Meta are getting from when you use an app or a website. And so I think that's what makes this case a little bit different.
Yeah. So to bring this up a bit and a bit more background for those listening at home, one of the reasons reached out to Michael and Carol was they are fresh off a case against Meta. They got a verdict on August 1, so we're taping on August 12th. 11 days ago. And this case had a few defendants and we'll go deeper into it in a moment. Flow was an app that would help essentially with family planning and relied on a software developer kit or SDK that Meta, which owns Facebook, Instagram, WhatsApp, and a bunch of other stuff. Meta provided that SDK to app developers. Let me stop there. Why don't you tell our viewers about how, just at a very high level, why would a company like Flow use that SDK and how that created essentially a pipeline of data between an app developer, in this case, Flow, and Meta?
Yeah, so essentially a software development kit is pretty ubiquitous, right? It's in a lot of apps. It's pretty normal for it to be out there. And essentially what it does, it's what it says. It's a software development kit. It helps developers who want to build apps, build their apps better, build them faster. It provides a service to app developers to help them do that. And it lets them track analytics, like how many people didn't make it through the first 4 questions because they were too long and boring when signing up for the app, or how many people purchased something. Um, but what a lot of people don't know about software development kits is that there's essentially a give and take, right? Meta provides a software development kit and it's free. So they're not charging anyone anything. And the app developer, in exchange, is essentially allowing Meta to record information that its users put in. And our case was based on a number of app events, like actions that people take within the app, that were sent over to Meta and were sent over with personally identifying information like uh, uh, advertising IDs and information of that sort. And this all came out in the trial, Meta was able to match the information that it received from the Flow Health app to actual Facebook users. And then they were also able to use that information in their machine learning algorithms to train their ad systems to deliver ads better. And we all know Meta is very, very good at delivering ads. And that's because they're able to access all this information.
I was, I don't know if you've ever read this book, but it reminded me, several years ago, there was a book by Charles Duhigg, and it was called The Power of Habit. And I don't know if you're familiar with this book, but it gives this anecdote in there about how this essentially involved data and how it was allowing essentially like retailers to track consumers, and talked about how this father stormed into a Target, asked to speak to the manager because his teenage daughter was getting coupons for pregnancy-related items. And essentially, Target was able to realize through this person's purchases that they were pregnant. And Target knew before the father. And I'm curious, where is the line between, advertising and sort of, targeting individuals based upon their purchasing habits, or a violation of a person's not just privacy but protected health data? Where do you where did you see that line, and did you ever sort of question, is it really fuzzy or is it pretty black and white?
It wasn't fuzzy here. I mean, and this came out at the trial, is the absurdity that individuals from Meta could not simply answer that where a woman was in her menstrual cycle is private information, or whether or not a woman was trying to get pregnant is potentially private information, or whether or not she was trying to get pregnant was private information. I mean, these are things that, and Carol and I joke about this, like, these are things that you don't ask. I wouldn't ask a female colleague at work. I may ask Carol where she went to dinner last night. I may ask her how her family vacation was with her kids and her husband. I would never ask those questions. And I think when you look at this type of data, and you look at the world we're living in, why that may have value, whether a woman's trying to get pregnant certainly has value. Whether or not, would an employer want to know whether a woman was pregnant or not? Maybe, maybe not, right? Where a woman was in her ovulation cycle, obviously, the highly sensitive and private information. And we talked to the jury about this, like the one tool that they had was common sense in making these determinations. To Carol's point, it wasn't a part of our case, but whether a woman is looking to buy a black jacket, I don't know if people would consider that a confidential communication. Maybe some would. And that gets into the gray area you're talking about. But the issues that we were dealing with were fairly egregious. I mean, it was not like I told the jury, this is not a close call. This is private information.
So now you say it's not a close call, but you just said you couldn't get Meta to answer some like basic kind of questions. And I wonder if it's just, and look, there's been a ton of reporting about this, that they just have this culture there that like nothing's private, and like, it's just with the world we're living in. Did you get that sense that, is it hubris, or really like they just don't have an appreciation of what should be private? I wonder if there's anything you can share about sort of that culture and I guess philosophy and way of business that they operate in.
I wouldn't want to comment on that. I will say, though, that the jury's verdict clearly sent a message that they disagree with their assessment on whether or not it was. And one of the arguments that we saw was at the end, Facebook or Meta made the argument, well, we had the consent of these women because they all were Facebook users, and our terms of service and our data policy allows us to collect from third parties any information we want, anytime, anywhere, and under any circumstances. And the verdict form which is public. The last question is, did Meta have consent? And it was a resounding X through that box. That the answer was no, they did not. Um, Look, I think when you're dealing with billions of pieces of data, maybe you become numb to the fact that this is private data of that individual, and you say, there's obviously, I'm not a psychologist, so I don't want to get into it, but like the idea that when you have it in the aggregate in the billions, you say, well, where's the harm? But it is a harm to that one woman that went on that app with the expectation that this stuff would be kept private. And it was recorded, and that was, and we still have laws on the books, right? California passed a law. Come back to the old fashioned, you pass a law, says you can't record this information. Recording devices come in all shapes and sizes in 2025. And when you break the law, you're going to be held responsible.
I know we're bouncing around a bit, but how did you even come across this case?
So I believe the FTC did an investigation into these practices. And at some point, Flo settled with the FTC, and it was very newsworthy at the time. And we looked into it and said, oh, this is interesting. I wonder if there's a there. I wonder, not, putting Flo to the side, like, what about the companies that they were sending the data to, Meta, Google? And so we started looking into it. We hired an expert to help us reverse engineer the app and see what the app and code traffic was going from Flo Health to Meta and other companies. And we looked at the law and we said, wow, I mean, this seems like a pretty bad breach of women's privacy. And, we did some research, and I think ours might have been the first case of its kind using SIPA, a wiretapping statute, to do this. But, like Mike said, we live in 2025. Wiretapping comes in all shapes and forms. And we decided, this fits squarely into the definition of a recording. And so that's how sort of the idea for the case came about.
So I know you also all worked on the biometric data case against, I guess that was just Facebook at the time. And so, no one puts Meta and privacy like in the same sentence, unless it's like they don't care about it. And when you approach a case like this, especially if we're going to go to trial against Meta, I mean, they have all the resources in the world. And did you, again, from the start, did you expect to go the distance? Especially since it's kind of the first case of its kind, did you think that they were going to do that from the beginning? Or if you could think back to when you first filed the case?
Yeah, I mean, you brought up BIPA. We went fairly deep with BIPA as well. And we had thought that was going to go to trial. They had taken that case up to the Ninth Circuit. They were unsuccessful at the Ninth Circuit, came back. The judge set it down. I believe he had set a trial date. I can't confirm that. But we were very close to trial there. And ultimately, we were able to reach a settlement. So I knew that there's a possibility that they would go trial. And to the point we made very early on in this discussion, Carol and I were always preparing with the expectation that it would go to trial. You have to. If you don't, you will get caught flat-footed. And that was one of the reasons why I think we were successful here, is that the class was certified in the spring, late spring, and then the judge had a pretrial conference in June and said, you're going to trial in July. And we were ready. We said, okay, like the expectation was that this was going to go to trial. So when we had the July trial date, we were prepared. We had anticipated that was a distinct possibility.
At the same time, and we talked about this earlier too, it's like only 1% of civil cases go to trial. So is this going to be the 1%? And only, I think, 0.7 go to verdict. Is this going to be the 0.7? Yes, it is. But, at the time, we're always looking for an off-ramp, right? We want to be able to bring value to the class. We want to be able to get them something sooner rather than later. And we understand that taking a case to trial takes a lot of time. Post-trial appeals take a lot of time. And at some point, you definitely want to be able to tell your class, look, here is the value that we're bringing you. We got a jury verdict. It's, $5,000, per user. And we want to be able to get that to them. But yeah, I think we were always looking for, some kind of off ramp. And you saw that we settled with some of the other parties. But I think for Meta, they have a lot of other cases that are sort of happening right now, right, in this area. They've got litigation around a pixel, which is the same type of software, but for websites. And I think for them, it was sort of a broader question, whether to settle or not.
Yeah, and
Talk.
it just anecdotally, I mean, without getting into too much detail, there was a moment where like Carol and I turned to one another and we're like, okay, this is really this is happening.
Yeah, like
There
actually
was a
really going to
moment.
trial.
Yeah, this is going to trial. Like we were kind of like, could it settle? And then at one point we were like, all right, this is it. This is really happening. And it was kind of like, okay, we're prepared, we're ready. But there was no doubt at that point that this was going to trial.
Yeah,
So I
there's
want to
always
talk about.
like a switch, sorry, like in your brain when you think about going to trial where you're like, okay, today is a day that you start working 24/7. And that happened, right? Like gearing up. So that was the moment Mike was like, yeah, we're going.
I want to talk about off ramps for a second. And I know you resolved against Google, and I saw some reporting where and again, I wasn't in the courtroom, but it seemed like the judge said on Flow, you should take the off ramp. And you did, and you resolved that confidentially. Did I'm curious when the judge said that, maybe it didn't come as a surprise to you, but did you ever, when you knew also the trigger was like, we're going to trial, did it ever make you question like, oh, like, what is the judge thinking about this case? Or you just saw it as a totally separate, they're obviously separate defendants, separate facts. But I'm just curious, at least the reporting, it seemed the judge was fairly direct in saying, where their mind was at.
The California Confidentiality of Medical Information Act, the CMIA, that was the statutory claim that we were suing Flow under. And it's actually a pretty new statute, unlike the wiretapping claim, which has been around for a very long time and has a lot of robust case law behind it, right? The Meta one. This one's pretty new. And, we also thought that our facts fit squarely into the claim and had been operating all along that way. We got to the end of the presentment of our case and the judge told us he was a little bit skeptical that it did. And so, we heard him. We heard him loud and clear. And again, I think, if you ask Mike and me, we'll sit there and we'll tell you, till forever and the cows come home that of course it fits within the statutory definition of the CMIA. But I'm not wearing the black robe, the judge is. And essentially, he looked at it a little bit differently than we did. That happens. And so you kind of have to take that into consideration when making your next strategic move.
Yeah, and on that, there were a number of other claims that we had against Flow that were still active. And I always, the mediation is confidential, but I'm always, this is like when we talk about, we talked about those that are still in the U.S. Attorney's Office. I don't know what's going on behind the scenes, so you kind of have to have a healthy respect for that. I would also take caution that the mediation necessarily wasn't a reaction to what a judge said. There are a lot of factors that go into whether or not you decide to settle a case. We had the opportunity to brief it. We would have had the opportunity to appeal if the judge made a certain ruling. So that being said, there are a number of factors that go into the decision-making process.
Yeah. I want to end with asking, and again, congrats on an enormous, outcome in, what's going to be looked back at, landmarks, first of its kind case. We are now moving though into a world where, so you have like, apps like Flow and, an SDK. We're now moving into the world of AI. And I'm curious if you can sort of predict out over the next, let's say 3 to 5 years, which I know is very difficult when all this AI stuff's changing, weekly. How does the data privacy landscape change in the world of AI? Do we see these companies being even more flippant with people's privacy? Is it going to be harder to uncover, though, whether that flippancy, leads into illegal conduct? I'd be interested to hear from both of you. And Carol, why don't you go first with, what do you think the landscape's going to look like?
Yeah, I don't think anybody knows, but I have a few guesses in mind. I mean, we actually dealt a little bit with the AI issue in dealing with this case because the data that got recorded by Meta from Flow got pulled into its AI algorithms. And one of the arguments that Meta made was, well, no person actually saw the data. It just went into the AI, machine learning system and it analyzed it and spit out ads for people or kept people engaged. I think that it's sort of an interesting thought that AI is not a person. Although we do know that corporations are people based on a Supreme Court decision. And so I think we're going to be seeing a lot of arguments around no one saw it. It wasn't a violation of privacy. It just got put into the machine and then the machine did something with it. I'm not convinced by that. I think that, you listen to the testimony of the women that we put up on the stand, and they felt very raw that their information and that their privacy was violated by their information being used. I also think that one of the things that we have that's very troubling is that, and our expert, Jen Goldbeck, talked a little bit about this, no one knows what happens inside the AI system. They call it a black box for a reason, and not any expert in the world can tell you what happens inside that neural network, how the data is used, where the data goes. It's just stuck in the training system, right, forever. And so that's also kind of troubling that once your data is out there, you can't get it back. And I think that's going to be something that, we're going to be thinking a lot about moving forward about, how is there a remedy for that?
Michael, anything you want to add to that?
No, I mean, I think Carol, hit a lot of the points. The one thing I would say is I'm not optimistic. I try to be an optimist, but we've saw.
I always try to end these on an optimistic note.
Yeah, well,
so you totally torpedoed that.
All right, so I will say I'm all right. So I will retract that and say I'm optimistic in that there are thankfully people like myself and Carol that are going to be watching, right? Because look, I think this technology is awesome. And we've always talked about that. Like we use it. It is a huge benefit. I think it has the potential for doing a lot of great things in medicine, in science, right? In education. The problem that we have is kind of goes back to where it's always been with a lot of these large tech companies. They don't get proper consent. They feel like they are kind of this benevolent actor that does this stuff so that it excuses the conduct that they engage in, which requires under the law that they get consent. We've always said that, whether it's BIPA, whether it's here under the CMIA, whether it's SIPA, under these statutes, you have to get certain consent. You have to let people know what you're doing. And 8 pages or 9 pages of a terms of service or a data policy that refers you to another hyperlink on another page that refers you to another page with a hyperlink with footnotes. It becomes absurd to think that consumers understand what's going on. So until these companies understand that they have to get proper consent and not roll out these new technologies and then ask for forgiveness years later, we're going to have firms like ours, people like Carol and myself are going to be watching, and we're going to be looking to bring these cases because consumers care about this stuff. They do, especially when they find out what's really going on. And that was the unique thing about this case. They finally got to look behind the curtain and see exactly what Meta is doing with the information and how they're using it and profiting off of it. So, I am optimistic that we will
Perfect. Yeah.
stand in reach. So
I will say, just to echo what Mike just said, the thing that I thought was so very cool about this is that people, like normal, ordinary people, actually got to listen to what happens to the data, see where it goes, what's done with it. They were told what happens and they gave a verdict, right? And it was resoundingly, we don't want this. And, you said before, the first of its kind, this is the first opportunity that consumers have had a chance to sit there and stand up to Meta and tell them, we don't want this.
With that, Carol Villegas, Michael Canty with Labaton Keller Sucharow, thank you so much for joining the podcast. Really appreciate you coming on.
Thank you so much.
Thanks for listening to this episode of Raising the Bar with Rebuttal PR. Don't forget to subscribe and follow to join us next time. See you then.